So I do a lot of FERPA because we get a lot of questions about it, but the First Amendment is really my thing. So I'm excited to be here to talk to y'all about this. We've had two in particular big First Amendment cases out of the Supreme Court. And I'm going to talk to you about both those cases. I'm going to have to put it a little bit in perspective so that you can kind of understand where these cases come from. So I want to go back and just really quickly go back and run through the various tests for student free speech. So there, up until 2007, we had 3 tests for student free speech. When do we violate a student's free speech rights by disciplining them or doing something because of their speech? So the first test is the school's tolerated speech. This is a test that says this is speech that merely happens to occur on school property. It's a coincidence. It's something on a shirt that they're wearing. It's speech that might have happened at the mall, might have happened in the evening, but it happens at school. We can regulate school tolerated speech only where it would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. This is the Tinker test. This comes from Tinker versus Des Moines Independent Community School District. This was a case, this is out of the Vietnam War. This is the black armbands case. So this is a case where they discipline students for wearing black armbands. And basically because that speech that only happens to occur at school, we can only discipline for that speech when it creates a material and substantial disruption. That's the Tinker test. The next case is actually on the far side in terms of timeline. And this is vulgar or obscene speech. So speech that is vulgar, lewd, obscene, and plainly offensive, we can prohibit that regardless of whether it creates a disruption. Now, that has to be speech that happens at school or on school property. That's not speech that happens someplace else. So it's a little bit more narrow category. And this is a case called Frazier, Bethel School District versus Frazier. This is another Supreme Court case. This was the student council nominating speech. This was a student who thought it would be really clever to get up and give a nominating speech that the 1986 Supreme Court thought was a graphic sexual metaphor. It's pretty tame by modern standards, but they disciplined the student for that. It didn't really cause a disruption, so it didn't really fall under Tinker, but they said you could discipline for it because it was vulgar or obscene speech. Then 2 years later, we get Hazelwood. Hazelwood is the school-sponsored speech. So remember, we have school-tolerated, which is speech that just so happens to occur on school property. Then we have school-sponsored speech. This is speech that, for some reason, we are perceived as a school district in promoting. Because of the platform, usually, of the speech, it sort of bears this, or at least it's arguably perceived to bear the school district stamp of approval. We can regulate that speech so long as the restrictions are reasonably related to a legitimate pedagogical concern. So it's a lower standard. So speech that we are perceived as promoting, we basically can regulate as long as it's reasonable. Speech that only happens to occur, it has to cause a material and substantial disruption. Up until 2007, those were our 3 tests, and we got fairly comfortable using those 3 tests. Then 2007 comes along, and we get Morse versus Frederick. This is the Bong Hits for Jesus case. And this is an actual picture of the students in that case. This is up in Alaska. The Olympic torch relay was going by, and the principal trooped all the students out to stand and cheer as the Olympic torch relay went by. And this young group of geniuses thought it would be really fun to unroll a banner that read Bong Hits for Jesus right as the runner went by, because the cameras were on them. They are literally standing right outside of school. They're not actually on school property, but it was considered a school event. So they were disciplined for that, and the case went up. And the court in this case basically said, they kind of on the fly created a brand new test and said the school district could discipline for this, even though it didn't really cause a material and substantial disruption, because it was perceived as being drug-related speech. So what does that mean as a test? Well, we don't really know. Clarence Thomas, writing in concurrence in that case, said, "I'm afraid that our jurisprudence now says that students have a right to speak in schools except when they don't. a standard continuously developed through litigation against local schools and their administrators. So Clarence Thomas is not a big fan of that particular test, but that was the bong hits for Jesus case. Now, Tinker, there's actually a second prong of the Tinker test. Remember, Tinker is the material and substantial disruption test. Tinker also talks about the invasion of the rights of others. So it basically says a student may express his opinions, even on controversial subjects, if he does so without materially and substantially interfering with the requirements of appropriate discipline and without colliding with the rights of others. So this is the forgotten Tinker test. This is the test that we use when we are disciplining students for harassment and bullying. So when a student is harassing or bullying another student, we look to see, are they invading or colliding with the rights of other students? So you might be forgiven for thinking that the First Amendment world has gone crazy. These are the two big cases that have happened. So last year we had Mahanoy. This is the cheerleader that was kicked off the cheerleading squad for saying fuck cheer, and the Third Circuit found in her favor. And then we had Kennedy, which was decided just a couple weeks ago, where the school district allowed a coach to pray at the 50-yard line. And I'm going to talk to you about both of those cases. So let's talk about Mahanoy first. If one PSA, if I achieve one thing, it's Mahanoy. It does not rhyme with baloney. Although now that I've said that, you will not be able to get that out of your head. So it's a school district in Pennsylvania. This is Brandy Levy. Brandy was a cheerleader, and Brandy failed to make the cheer squad. She was very upset as a 10th grader. She was very upset. She went home and she posted a picture of herself giving the finger to the camera and on Snapchat with the caption, fuck school, fuck softball, fuck cheer, fuck everything. So we've got school, softball, cheer, everything. We know Brandy's opinion on the matter. It was also worth noting that she then followed that up with a second one that basically complained about the fact that a freshman made the squad and she didn't. So now the Third Circuit ruled that removing her from the JV squad for a year, which was her punishment, violated the First Amendment. What scared the living daylights out of every school district was this last sentence, where the court said, we hold today that Tinker does not apply to off-campus speech. So arguably, the Third Circuit ruled that school districts did not have jurisdiction over any off-campus speech. That's the reason why this case was appealed. So if you ever wonder, if you were hearing about this case and you're like, oh my God, it was a dispute over cheerleading, why in the world did somebody appeal this all the way to the US Supreme Court? That sentence was why. That's the reason why this case had so many. So when you go to the Supreme Court, you can file what's called an amicus brief. So any organization can petition to file a brief with the court and explain to the court why they think one side should win or why they think the law should be a certain way. Those are called amicus briefs. It's amicus curiae, it's Latin for friend of the court. I actually filed an amicus brief in Mahanoy on behalf of the Pennsylvania Association of Secondary School Administrators. Pennsylvania Association of Secondary School Administrators. Don't ask how I got involved with a group in Pennsylvania, but they were looking for people to try to help out and explain to the court. So anyway, that's the sentence that terrified all of us, because we have cyberbullying, we have sexual harassment, we have lots of things that we may need to discipline a student for, particularly when they are speaking on social media. And that sentence scares the living daylights out of everybody. Now, what was interesting was by the time the case got to the Supreme Court, even the plaintiffs weren't defending that sentence. So the good news is, again, depending on your viewpoint, the bad news is Brandy won the case at the Supreme Court. They ruled in her favor. The good news is the Supreme Court made it very clear that they were ruling on her favor for a different reason, because Justice Breyer, who wrote the opinion, said, unlike the Third Circuit, we do not believe the special characteristics that give schools additional license to regulate student speech always disappear when a school regulates speech that takes place off campus. So the court ruled that school districts did, at least under certain circumstances, have jurisdiction over off-campus speech. And that was really what everybody wanted. That's the reason why the school district appealed this to the Supreme Court. Now, the court, they went on to say that these categories include things like serious or severe bullying or harassment, targeting particular individuals, threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of paper, the use of computers, or breaches of school security. So there are certain categories of things that we do have jurisdiction over, even when it's speech that takes place off campus. Now, unfortunately, Justice Breyer was very hesitant to actually then give us a test as to, okay, well, when? We know sometimes we have authority. When do we have authority? And he was very hesitant to do that. He did say that the court should look at various things. They should look at the student's age. They should look at the nature of the school's off-campus activity and the impact upon the school itself. He did say that there were 3 things that should basically weigh against a school being able to discipline. First, he said, with respect to off-campus speech, a school will rarely act in loco parentis. Now, this sentence actually scared all the other school lawyers because the in loco parentis doctrine had been going away. It actually creates more problems than it solves. We weren't using it anymore. This decision brought it back with a vengeance. So now we have the concept of school districts acting in loco parentis, which basically means standing in the place of the parents when the student is at school. So this makes a little bit of sense. When the student's not at school, we don't stand in the place of the parents, right? One of the big themes in this case was that it should be the parents disciplining these kids for this kind of speech. And that's a legitimate argument to make. We all know that oftentimes the parents don't discipline the kids for things that they do off campus. Sometimes the parents aren't even there anymore, but it does make sense to say the parents, at least first, should be the people who should be disciplining for this. This is one of the major themes that the plaintiffs argued along with the organizations that were supporting them, the amicus organizations. Second, if you think about this from a student speaker standpoint, if the school has jurisdiction over my speech when I'm at school, and the school has jurisdiction over my speech when I'm not at school, and I sleep some hours of the day, then the school has jurisdiction over my speech 24 hours a day. And the court was skeptical of that. So we need to take that into consideration when we're looking at off-campus speech that's made outside of the school day. And then third, the court went out of its way to point out that the school has an obligation to protect unpopular viewpoints. That is the purpose of the First Amendment. That's always been the purpose of the First Amendment, is to protect unpopular and minority, and I kind of mean minority political viewpoints. And so the court said unpopular speech deserves more protection, not less. Ultimately, Brandy won this case. Why did she win? Because under the Tinker test, they couldn't show a material and substantial disruption, and they really couldn't. Her speech didn't create a huge disruption in the class. There were some hurt feelings. That was really about it. They looked at things like the fact that her tweets were intended to contain an actual message criticizing the rules of the cheerleader community. That was a little bit of a stretch given what she actually said, but okay, so she's criticizing the cheerleader community. They didn't amount to fighting words. This was kind of interesting. According to the court, they were not obscene as this court has understood that term. Not sure what they think obscenity is, but that's what they said. They were posted outside of school hours from an off-campus location. She was at the Tiki Hut on Saturday when she posted that. They did not identify or target any particular member of the school community. That is a crucial fact because that is what we use to distinguish this case when we're dealing with things like bullying and harassment. And they were transmitted using her personal cell phone to a private circle of friends. Now, the one thing, although the court didn't provide us with any new rules, the court actually said we want to leave that to further cases to sort of experiment with how are we going to apply Tinker to off-campus speech. Tinker is 50 years old at this point. There are thousands of cases applying Tinker, and almost every circuit, and our country is divided into circuits. We are the Fifth Circuit. Almost every circuit has its test and its case for applying Tinker to off-campus and online speech. But the court didn't want to look at any of those. They said, we will leave it to the future. So they did not overrule any case that came before. So this case is the Fifth Circuit's case. If you were interested in this subject, this is the case you want to look at. Bell versus Itawamba County School Board. It's actually out of Mississippi, but that's the same circuit as Texas. And this was basically a case of a student who created a rap song that he posted online, and in which he basically threatened to kill several teachers over some allegedly harassing a female student. And the court there said, we hold Tinker governs our analysis as in this instance when a student intentionally directs at the school community speech reasonably understood by school officials to threaten, harass, and intimidate a teacher. So if it's online speech, but it is aimed at the school community, and that's a key phrase, it's something that we have jurisdiction over under our Fifth Circuit test. This was not disturbed by Mahanoy. So what lessons can we draw from Mahanoy? First of all, it's very clear that the court believes that there is a sphere outside of school where students should be able to say and do whatever they want, subject to parental discipline, not our discipline. Now, where is that sphere? How big is it? When does it occur? We don't know, because the court decided they weren't going to give us the answers to any of those questions. We're going to leave that to further litigation. But there is clearly a sphere where we should not be going. That's lesson number one. Lesson number two, and this is what scared everybody about this opinion, is that we need to be very careful about our extracurricular codes of conducts or our athletic conducts, because they frequently are where we try to exert jurisdiction over students outside of the school setting. And I have seen some really, really broad and vague standards in some of these. I was looking at one. I actually have a lawsuit. It's in here. I'll point it out in a minute. Where the athletic code of conduct says male and female athletes shall be ladies and gentlemen at all times. That's a pretty broad standard to then discipline somebody for violating that. So you want to go back and look at your codes of conduct. You want to make sure that to the extent they allow you to discipline, that they focus on speech that targets the school community. Remember, that's Bell, and that can be reasonably forecast to cause a material and substantial disruption. That's the Tinker test. And again, athletes should be good people is great aspirational language, and we can tell them that, but that's not really a standard for which you discipline. And then the third lesson is schools should be very careful about disciplining students for religious or political speech. Now, what was interesting about this, if you watch the oral argument, which was actually really interesting at the Supreme Court, and this was all done online, so it was all done through Zoom. If you watch the oral argument, you would be forgiven for thinking that this wasn't a political or religious speech case, because that's all they talked about. They didn't ask a lot of questions about online platforms or off-campus speech or social media, probably because most of the Supreme Court can't figure out what social media is. But they spent a lot of time grilling the attorneys about, well, what about religious speech? What about political speech? And in the sentence, the first bullet point, first sub-bullet point says, when it comes to political or religious speech that occurs outside school or a school program or activity, the school will have a heavy burden to justify intervention. So for a long time, some attorneys have been trying to argue for a kind of a higher standard for political and religious speech as categories. This kind of gets there. So you need to be very careful when you're looking at that off-campus speech. So is Mahanoy is it destined to become another bong hits for Jesus case? So when Morris versus Frederick came out, we all freaked out. What does this case mean? It's, okay, drug speech, got that, but, does it apply to anything else? One case applied it to threats to shoot up a school and said it was kind of the same thing. Other than that, it really hasn't been used for anything. You don't see Morris versus Frederick get cited in virtually anything. It's kind of a dead case. Is Mahanoy going to be, kind of that same thing? It might not really be a case that has a major difference. It achieved the goal that all the school districts wanted, which was to get that sentence from the Third Circuit out that said they couldn't discipline for off-campus speech. The fact that it didn't provide much standard beyond that, it makes it a difficult case to figure out what are we going to do with it. There had been a number of cases since then that have almost entirely rejected Mahanoy as a grounds for ruling in favor of a student. So this is McClellan versus Katy ISD. This is my case. This was a high school football player, quarterback, who was suspended for 2 games and removed from his position as team captain for sending a video to a student at a rival school that said, "We'll put your mother effing ass in the hospital, N-word, what the F." And that was sent to another student right after a very contentious game when he was literally trying to draw the student out of Whataburger into the parking lot so that they could get into a fight. The court in that case ruled in favor of the administrators who disciplined that student and said that, you know, this was clearly a threat to another student. It was not the same thing as Mahanoy. Now, this case is on appeal. This was the Southern District of Texas. The Fifth Circuit is looking at this. The briefing in this was actually, we filed our brief last week. They get one more brief. So if you're interested in this, there will be another decision from the Fifth Circuit in this case. I don't know whether it'll have anything significant in it, but that's one example. And then there's AF buying through Fultz versus Ambridge Area School District. This is a case out of Pennsylvania. Pennsylvania is actually where Mahanoy started, that same state. This was a Snapchat group among athletes, and it kind of degenerated. It started out with an assistant football coach asking the athlete why he wasn't at conditioning practice, and it went downhill from there really fast. And it ended up with one student threatening to, among other things, show up at practice to beat your ass, bitch. And again, this student said, "I have a protected right under Mahanoy to say these things." And the court said, "No, you don't." So they rejected that. Mahanoy offers him no shelter because here we had actual threats and it was threatening language directed at a particular student. And so, again, not the same thing as Mahanoy. We have Brianna Cheadle. This one, actually, you might have heard this one made the news. This is Western District of Missouri. This was an 8th grade student who was suspended from the volleyball team after she recorded a video of herself binge drinking alcohol at home over the weekend to the point where she passed out. Her mom found those videos and got in a really nasty argument with the other girls on the videos about what had happened. And she claimed that she had a right to post these videos. And the court here said, but they didn't discipline you because of what you said about drinking. They disciplined you for drinking. Okay, now putting aside whether they should have been doing that, you know, when it wasn't on the weekend, that wasn't the issue in this case. So conduct is different than speech is the point of this case. So if you have somebody who posts a video of themselves brandishing a gun or something like that, or using alcohol or drugs, that's not the same thing as pure speech. So that's what this case stands for. So the bottom line is we haven't really had a major case yet where they've upheld a Mahanoy kind of argument. So we'll see how that case plays out. Now let's talk about Kennedy. This is a case that was decided a couple weeks ago. And this is the coach. So Kennedy, we're going to talk about Kennedy. I need to hear there are a number of tests for determining this is the Establishment Clause. The Establishment Clause, the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the First Amendment. That's about how much guidance it gives. And that's what we're looking at in these kinds of cases. So the Establishment Clause generally prohibits somebody or prohibits the government from engaging in any activity which may tend to establish or promote any specific religion or that is hostile to religion. It's both sides of the equation. So for a long time, we used a case, something called the Lemon Test, and this came from Lemon versus Kurtzman. This was developed in the early 70s, and it basically said that a practice would pass constitutional muster if it met 3 prongs: the legitimate, secular, non-religious purpose for the activity, that's the purpose prong; if the primary effect of the activity neither advances nor hinders religious belief, so you've got the purpose prong, you've got the effect prong, and then if the activity does not excessively foster, it doesn't foster excessive entanglement between the government and religion. So for a long time, this was the test that we used. It was called the Lemon Test. If you meet all 3 of these requirements, it's constitutional. If it fails any one of these, it's not constitutional. Now, Lemon was a highly criticized test from the start. Justice Scalia, who was always known for colorful quotes, once said, like some ghoul in a late night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our establishment clause jurisprudence once again, frightening the little children and the school attorneys of Center March's Union Free School District. So this had been a long criticized test, and it got to the point where the court would use it when it would use it, and it wouldn't use it when they didn't use it, and there wasn't a lot of rhyme or reason as to when which drives attorneys nuts. So we get to 2019, and we get to a case called American Legion. This was the case involving the Bradensburg Cross in Maryland. This is a 40-foot tall cross that's maintained by the city as a war memorial. It's a really, really, really big cross, and it's right in the middle of a traffic circle. So you're driving by it like all the time, but it was a war memorial, and it had been there for like 72 years. It was old. And Justice Gorich in that case basically said, Lemon was a misadventure. It sought a grand unified theory of the Establishment Clause, but left us only a mess. So in American Legion, for a long time, we had this one test, the Lemon test, that applied to everything. And that was the problem. It worked okay in certain circumstances, and it didn't work okay in other circumstances. That's why the courts kind of stopped using it. And so, the court starts to get to the point where they're like, we don't need a grand unified theory. Let's have different tests for different kinds of situations. Because remember, when we were talking about free speech, we had 3 different kinds of student speech. And then 4, if you count long hits for Jesus, and then 5, maybe with Mahanoy. So we've got different categories of speech, and for those different types of speech, we have different tests. Well, that's what the court started to do here. They actually created about, well, it depends. They called it 6 categories of speech. I swear it looked like 7 categories of speech. Justice Kavanaugh thought it was 5 categories. I have no idea how he came up with that number. But it was clearly an effort to start creating different categories and coming up with different tests for them. Now, the endorsement test is a test that Justice O'Connor used. This was sort of a gloss on Lemon, and it basically said that the government violates the Constitution if they are perceived as endorsing religion. So it's kind of similar to the Lemon test. We also had the coercion test. This is the test that says that the government can't coerce somebody to engage in or abstain from religion. The most famous case here is Lee versus Weissman. This is the prayer graduation test. This was the case that prohibited school districts from holding prayer graduation because it was deemed coercive for students to have to participate in the prayer as part of going through their graduation ceremony. We then had the historical test. Now, the historical test had always been kind of made, everybody kind of made fun of it. And if I had done the speech 5 years ago, I might not have even mentioned it. It was used in a case called Marsh versus Chambers. Marsh was a case that involved the state of Nebraska legislature there, starting every morning with a prayer. They had a chapel, the chapel would give a prayer. And so that was challenged. Now, that's not going to pass the Lemon test. It just isn't. And the Supreme Court wanted to hold the practice. So they went with this history test, and they basically said that there is a long-standing history of engaging in prayer to open legislative bodies, legislative prayer. And one of the things they pointed to, and this is a favorite argument of the conservative and the originalist side of people who interpret the Constitution, is that the group of congressmen, because they were all men back then, who originally passed the First Amendment, 3 days later, they hired a chaplain to begin congressional sessions with a prayer. So whatever the First Amendment means, those guys knew what it meant and must not have prohibited you from hiring chaplains because they did it 3 days later. That's the Founding Fathers argument. When you hear references to, well, we need to do what the Founding Fathers did, that was the argument here. And it made sense there to a degree in this limited situation. The historical test had not really been used by much. We started to see a neutrality test. This is Espinoza. This is one of the voucher cases from 2020. And we've had a lot of voucher cases recently. Here the case basically said the government has to act neutrally. If you allow a voucher for non-religious schools, you have to allow it for religious schools. and it violates the Constitution to treat religious schools differently. So we have a growing neutrality test, and then we get to Kennedy. So this is the case that was just decided. In 2015, Joseph Kennedy, who was a high school assistant football coach up in the Seattle, Washington area, was disciplined after he insisted on kneeling and praying on the 50-yard line immediately following football games, in full view of and frequently surrounded by and joined by other people. Now, the next slide now. I wrote an article, and I'll point it out in a second, called A Tale of Two Football Fields, in which I talk a whole lot more about this case. And the reason why I said that is, if you read the majority opinion and you read the dissenting opinion in this, you're going to think you're looking at two completely different school districts and two completely different football games, because their version of the facts are incredibly different. Now, that's not uncommon in cases. We disagree on the facts, but it is extreme to the max in this case. So if you believe the majority, Coach Kennedy, as he's basically kind of going from the football field to the locker room, would just sort of detour past the 50-yard line, drop to his knee, give a brief prayer by himself silently, and go on. And that's it. That's about how long it would take. Wouldn't involve anybody else, wouldn't invite anybody else. And that during this time, the court determined that this was free time for employees, and they were free to do kind of whatever they wanted. I've looked at the record in this case pretty extensively. That is not what was going on there. These were huge group activities. The coach was actively going out on social media and inviting people to come down and pray with him. You had multiple members of the team. You had people from the community. You had upwards of 50 to 100 people, coming out to pray. And it was a spectacle, at the 50-yard line. It got to the point where a local Satanist organization was actually at one of the games because they were going to demand an equal right to pray. If you let other people pray, you got to let us do our thing. And so they were getting ready to do that. They didn't, only because that was a game where things got out of control and the police kind of locked it down. And the Satanists actually, they showed the most self-restraint of everybody. They just decided they were going to stay in the stands and not do anything. And as most of you know, these coaches were not free to just go do whatever. They were supposed to be supervising students during this period. I mean, they're literally supposed to be shepherding the students from the football field to the locker room to get them home. So the idea that this was free time where employees were kind of free to do whatever they wanted wasn't really true. And that's how the two sides viewed this case. So Coach Kennedy argues that the school district's decision to place him on administrative leave violated both his free speech and his free exercise rights. And the school district said, but we have to do that to avoid violating the Establishment Clause. So I'll run through this opinion fairly quickly. Under the free exercise clause, Justice Gorsuch wrote the majority opinion. It's basically a 6-3 opinion. It's kind of a 5.5, 4.5 opinion because Justice Kavanaugh, for some reason, decided he didn't want to join one of the sections on free speech. He does not write separately to explain why, so we don't really know why he didn't join it, but he did not sign off on that part. That's one of the when you're a lawyer, that's one of the frustrating things in the Supreme Court opinions. You've got 9 Supreme Court justices, and sometimes it's a 9-0, sometimes it's a 5-4, and you've got all these concurring opinions and different things. And then you get people who will say, well, I like that paragraph and I don't want to be in that section. And it gets super confusing. That American Legion case I mentioned has like 7 different opinions and is impossible to follow. This one is like I said, it's kind of a 5.5, 4.5. But with respect to free exercise, the court basically said that because other coaches were permitted a minor respite from their supervisory roles during this period of time, that it violated his free exercise rights to not let him pray during that when you would let other people do other non-religious things during that time period. And that kind of makes sense. I don't necessarily disagree with that. I don't really know that that's what was going on in these games or what was supposed to be going on. But, if you do allow employees to do their own thing during a period of time, then a brief religious observation would not necessarily be amiss. When it got to the free speech, the big question here was, is he praying as a private citizen or is he praying as a school employee? And again, it kind of comes down to, is he acting as an employee at the time he does this? And again, the court, the majority, minus Justice Kavanaugh for some reason. Justice Kavanaugh, incidentally, is the only Supreme Court justice who played football in college, or in high school, so he may know something the rest of us don't. The majority held that his speeches were private prayer, and that that people would perceive them as being private. And again, they focused on the fact that during this time period, supposedly people were allowed to kind of do whatever they wanted to do. They talked about how people were free to engage, speak with their family members and with other people in the audience, use cell phones, check emails, and engage with the opposing team. And so they said he was not acting as an employee. That basically says the same thing. So then we get to the Establishment Clause. Now remember, this is what the school district was focusing on, was the Establishment Clause requires us to stop a religious activity from going on. And they were basically saying, look, this is not that different from Lee versus Weissman. We can't have prayer at graduation. Doe versus Santa Fe. We can't have prayers over the loudspeaker before football games. It's basically the same thing. And there are a number of oddities here. The court basically said that there really isn't any conflict between the Free Exercise Clause and the Establishment Clause, that they are complementary, that there is no tension between them, which is interesting because there are about 60 years worth of Supreme Court opinions from all kinds of judges talking about how there is tension between those two clauses. So that's a little odd. The court then rejected the Establishment Clause defense and said that Lemon, they didn't actually overrule Lemon. They actually said that Lemon has been overruled for years. We're not sure when that happened because there is no case saying it's overruled, but apparently it's been bad law for a long time. So what did they decide should take Lemon's place? Well, they kind of gave us a test, and they gave us the history test. Now, remember, up until now, the history test had been kind of the stepchild of tests. It was not like, it wasn't used very often. It was rejected a lot by other courts, and it was used primarily to justify legislative prayer. The case that's mentioned there, Town of Greece versus Galloway, was a case involving prayer at a city council meeting. So it was the same thing as that Mark versus Chambers case. But they decided that we now have a history and traditions test that requires us to interpret the Establishment Clause by reference to historical practices and understandings, drawing the line between the permissible and the impermissible in accord with history, and faithfully reflecting the understanding of the Founding Fathers. None of us know what that means, but we're supposed to look to history, and we're supposed to look to the intent of the Founding Fathers. After it dismisses Lemon and talks about this, it doesn't really apply this history test to the facts of this case. It just sort of leaves it for the lower court to do that when they send the case back down. So again, we don't even see in this case how the Supreme Court would take this history and tradition test and apply it in this situation. They just kind of said to the court, they said to the Court of Appeals, you used the wrong test. You never should have used Lemon, and therefore do it again. So we'll see what the Ninth Circuit and the Supreme Court don't like each other. The Ninth Circuit is California, Washington, Oregon, Nevada. It's the West Coast, and they constantly disagree with each other. So who knows what they'll do with this case when it goes back down. So the district's last argument was, well, wait a minute, we can't do this because this coerces students to engage in prayer. And the court said, but Justice Kennedy said he didn't tell any students they had to engage in prayer. Okay, that may be true, but there's indirect coercion, and you have an adult figure who's praying, and our football player really not wanting to engage in this if they're nervous about being, and there was evidence from students that they did this because they didn't want to get in trouble with their coaches, and they didn't want to get in trouble with their other students. And in the past, the courts have given credit to that. The Supreme Court just said, no, it doesn't really count. So because there was no evidence that he directly told somebody they had to engage in this practice with him, the fact that other people might indirectly be forced into engaging was not deemed sufficient. And that's a huge departure in how the courts have looked at coercion before. And again, that was relying almost entirely just on his assertion there. All right. There are a lot of problems with this decision. Again, it's not an issue of whether you like the fact that he engaged in prayer or not. That's a different issue. But just how the court went about looking at this, it's so different than what we've dealt with before. It's such a different test. Lemon was a flawed test. There is no doubt about that. It's been problematic for years. But to get rid of it and replace it with the history and traditions test, which is even weirder, I don't know what we're going to do with that. If you're interested in this, and I don't have that much more time to talk about it, I actually have a blog. And if you want to go and look at it, it's at theoldestrule.com. There's a much longer article there if this is something you're interested in. But just to kind of go through, again, as the dissent said, to the degree the court portrays petitioner Joseph Kennedy's prayers as private and quiet and misconstrues the facts, I agree. That was not really what was happening. The majority almost completely eviscerates the Establishment Clause by elevating the rights of the individual versus the rights of the Establishment Clause. That's actually pretty typical of what they've been doing in this area. It's true of all the voucher cases they've been deciding too, where they basically said if somebody wants to use the voucher, they can use it for whatever they want, and the government does not have doesn't have to regulate the use of those. Again, they've criticized Lemon for its misguided attempt to create a grand unified theory for all Establishment Clause cases. And then they go and do the exact same thing, just with a different test. So now we have history and tradition instead of Lemon. The history and tradition test is utterly undefined. Whose history and tradition are we talking about? I mean, different people view these things differently. I think we all know that what history was back in 1789 when they were adopting the Bill of Rights is extremely different than how we view things today or how they view things in the mid-1800s. So, again, do you really want a constitution that is locked in as people would have viewed things back when they didn't have public education for the most part? And you can go back when you're criticizing history and you're criticizing going back and looking at the intent of the founding fathers, that's a legitimate point, is that there are all kinds of things. The founding fathers didn't draft the Second Amendment viewing, AK-47s because that's not what they had. I mean, there's all kinds of things. There are a lot of problems with using the founding father theory. And I think we're going to have a problem going forward. And then the coercion analysis just isn't really grounded in reality, because we all know that what adults do in a student's life can have an indirect coercive effect on them, even if the adult never technically said, you must go do this. So again, I don't think that analysis was very good. So where are we going to go from here? I think we're going to see a lot of challenges over the next couple of years to a lot of practices that we had kind of put to bed as to whether they were, good or bad. And some people may like that. I mean, some of you are probably thinking this is going to be great, but there's going to be a lot of litigation because, it was not a good idea. It almost would have been better if they had just said, we are overruling Lemon today. But pretending like it hasn't been good law for a long time, even though that's true, basically says that any case that's been decided during that period using this test was a bad case. So you're going to get people going back. You're going to see challenges to the prayer graduation and the prayer football game cases. Now, the Kennedy majority actually did distinguish what happened there, which was a individual praying, as they viewed it, from the group prayers that were set up by the school district and monitored by the school district in both Lee versus Weissman and Santa Fe. And so I think the court itself is discouraging people from challenging those practices, but somebody's going to do it. I think the bigger question is going to be, do school districts still have an obligation to stop employees from engaging in religious activities in the classroom? So a teacher who starts, interjecting their own religious views into a curriculum where it's not warranted or appropriate. The cases have always been crystal clear that school districts can put a stop to that. But now I think people are going to say, but that's not true. The one, I guess, good thing, if you're a school district or school administrator, the one good thing about the crazy facts that the Kennedy court said happened is that that's what we're going to point to. So when somebody comes and says, hey, I can, pray in my classroom to students, we're going to say, under Kennedy, we're going to say no, because Kennedy involved speech that was outside of the classroom, and it was, individual person, and it was by themselves, and it was quick, and it was silent, it was quiet. So I think we're going to focus on those facts as if they were true, to distinguish between something that somebody wants to do that we don't think is appropriate the Kennedy case. But we are going to get a lot of requests from employees, especially over this next year, for to engage in religious activities, probably in the classroom as a form of accommodation. And then again, the other biggest problem is we just don't know what ageless principles and history and tradition means. And courts are going to be all over the map on how they interpret that. I think just from a legal standpoint, you know, we like objective tests that are easy to apply because they lead to consistency. This is going to be crazy because it's literally going to be whatever the judge thinks you know, history calls for in this particular situation. So that's the current status of the First Amendment. I wish you guys luck trying to deal with this brave new world. And maybe if I come and talk to you 4 years from now, we'll have another crazy case and we'll talk about whether that case is going to change things up again.
Any questions for Chris?
I have a question. You were talking about the prayer in the classroom. So if a student came up to you and confided in you about something and asked you to pray with them about it, are you breaking the law?
Prior to this case, yes. After this case, maybe not. I'm not saying you were breaking the law before that. It's not necessarily a good idea. It could get you in trouble. I mean, there are cases that have found that to be unconstitutional, to be a violation of the Establishment Clause, because as a teacher, particularly in the classroom during the kind of classroom hours, instructional day, you know, you are engaging, you are acting as an employee, not as an individual. And so, yeah, that would be problematic. Yes.
Like in some board, you know, some board policies, like, okay, you can't do this, if it's gonna cause undue hardship to the school. But like they have one, that case really interesting. And they said, one of the judges said, and they pushed back against argument, this might have so obvious for John Kennedy, stressing learning how to tolerate speech or prayer of all kinds is part of learning how to live in a pluralistic society. A trait of character essential to a tolerant citizen. And I just found that interesting that he said that. I mean, I don't think it's necessarily wrong, but they were saying that in response to, well, okay, if people have issues with it or it affects a child a certain way, well, they need to learn, you know, how to something else.
So that's a really interesting question that you focused on that. That's the look away argument. So, oh, it's no big deal because you can always look away. You don't have to watch that. That argument has always been rejected by the courts, that people of a minority viewpoint, minority religion, whatever, are not required to look away and tolerate something that the majority is doing. Remember, the whole point of the Bill of Rights is to protect minority viewpoints and things like that. That was its major goal. So that statement is a little scary, and Justice Gorsuch is known for throwing those statements in his opinion. So it'll be interesting to see if they do focus on that. Yeah. On court packing, it's a bad idea. It's a bad idea for no reason that if one side adds 5 justices to shift the burden, then the next time they get in a problem, they're just going to do it again. Now, I actually think it wouldn't hurt to have some more justices. It wouldn't hurt to come up with a system. So the courts of appeals actually have a system where when you appeal to the courts of appeals, you get a panel. It's a randomly chosen panel of 3 judges, and they hear your case first. If you don't like their opinion, you can either appeal directly to the Supreme Court, or you can ask for a rehearing of all the judges. That's called en banc. And there's something like, I think this circuit, there's like 18 judges now, or I don't remember how many exactly it is. They talked about maybe doing that with the Supreme Court, because the Supreme Court they only take like 80 cases a year. That's not many. And so they could take more cases and they could maybe handle them quicker if they had more of a system like that. So I think that there are some things we could do to the court. I wouldn't be opposed to term limits of some sort or things like that. I think there are some reforms, but I really don't think court packing was a good idea because it's so temporary, because we could end up with a Supreme Court with 100 people on it because they just keep adding more people because they don't like the makeup. Yeah. Mhm.
I'm not in a history class, but anything like that, but, you know, when the presidential elections happened, we were students who come to school, and I would be discussing it amongst in my class, during free time or whatever, and sometimes they would want to ask me my opinion. Is that something that we can share or not?
So I'll preface this by reminding you, I am a school board attorney, so I work with the administration, not with teachers. I know, and we just got done with a conference, the school law section of the state bar in San Antonio, and we have everybody, we have both sides of the bar. And I know that all my employee attorney would disagree with me on this. I don't think it's a good idea to share your personal views. You can get, I'm not saying it violates the law. I don't think it does. But it can get you in trouble, particularly if, for example, as a math teacher, it's something that isn't necessarily, you know, something that you would be teaching. So it's not curricular speech. It can get you in trouble. It probably won't, but it can. So I would counsel against that. And some, oh, there. Mhm.
Being told, you know, everything that's going on, often a student breaking the law,
Yes,
but if the student initiates it and asks you to do it.
still violates the law. Arguably, there's not a case out there that says that it's never been challenged, but I would point this out. And I know this is, and again, this is me as a school board attorney. Counselors, that's their job, is to do this. And I get it. I know as teachers, sometimes you have a better relationship. And I certainly understand that, but that's not something that is necessarily part of a regular teacher's job duties, at least from the school district's perspective. And so engaging in speech like that would arguably be violating the Establishment Clause. Although after this case, I don't know what the court would say. So, yes.
But any religion is prohibited. So let's just say, this guy wanted to pray, and he wanted whatever, but, and he, I'm assuming is a Christian. And then what if, somebody that was a Muslim wanted to do the same thing? Like, there's no, I mean, they can't, right?
The Satanists in Seattle have already put in a request at this school district to be allowed to go out and pray on the 50-yard line. Yeah, and that's actually a really good point. You got to be a little bit careful what you wish for, because what's good for the goose is good for the gander. And I'll just give you an example that actually, so the Equal Access Act, when that was passed, that is the federal law that says that basically it says if you allow one club to meet, you have to allow all clubs to meet. That's the Equal Access Act in a nutshell. That act was passed to force school districts to allow Bible clubs to meet. That was its genesis. Arguably, they already had the right to meet, but they wanted a federal law, and so they passed that law. It is predominantly used now by LGBTQ clubs to meet. I constantly hear people say, but that's not what this law was passed for. Well, no, but that is what it says. So you're absolutely right. You know, ask yourself this: are these same parents in this case who were happy for their kids to be out coaching with praying with Coach Kennedy, if the next coach, if he leaves and the next guy who comes in is Muslim or Satanist or whatever, and they want to go out and do the same prayer, but from their religion, are those same parents going to be happy? No, they're not. Some of them might be, but you know, some of them are not going to be. And so you got to be careful what you wish for, because we are living in a more pluralistic society. And a lot of these standards are now based on neutrality and treating everybody the same. And that does mean everybody. So, yes. All right, now that I've made everybody mad. All right, well, good luck with the new school year.